right. Well, good morning, everyone. Thank you for joining. My name is Stephanie Giorgio. I'm the events manager with Mississauga Board of Trade. Thank you, everyone, for joining this morning for such a great session with Jonathan with Kaiser Mason Ball. We are recording today's event, and the link will be available on our site in the coming days, right on the MBOT site in the news section. We will be taking questions, some throughout the event, and as well as towards the end of our event this morning. So definitely use your chat button at the bottom of your screen there to enter all of your questions for Jonathan. So today, our webinar is on the 2022 updates to Ontario employment law. And we have there so far that Jonathan will go into for this year. Our speaker is Jonathan Borelli. He is the leader in employment and labor law with Kaiser Mason Ball. So thank you, Jonathan, for joining us this morning. I'm going to hand it over to Jonathan. He's going to go through his presentation. And as I mentioned, this is being recorded, and we do have a chat box open for questions at the end of the event today. Thank you.
Thanks, Stephanie, and good morning to everyone. I'm very happy to be here. As Stephanie said, I'm one of the employment lawyers here at KMB, and we're a firm in Mississauga, a full-service corporate firm. We help employers and corporations with employment matters, buying and selling, any corporate matters, real estate transactions, wills and estates, and litigation, commercial litigation, construction matters, really almost anything a corporation needs, we help them with. So I'm very happy here today to talk about the 2022 updates to employment. Now, you'll see on the title, I added so far, okay? 2022 is only about half done. And there have been many different updates and changes and clarifications to the law. So I wanted to take our time today to go over the more significant changes for employers. And so if you have any questions, feel free to put them in the chat. If they're related to the topic that we're discussing, I'll address them perhaps at that time. And I have some time at the end for questions as well. So to start, I just wanted to give a really brief overview of what I want to talk about today. There were two laws that were passed at the end of 2021 and in 2022 called the Working for Workers Act. It was such a good title that they named the law twice. They had two different laws with the same name. They just changed the year at the end. But my focus today, I really want to talk about the case law, or in other words, common law, judge-made law. And those are changes that you won't really find in the legislation. If you go into the Employment Standards Act or the Occupational Health and Safety Act, you won't find some of those changes. And so it's really, on a, as we say, a case-by-case basis where these changes to the law take place. So that's really my focus for today. But generally, we'll talk about those three things. Now, of course, we cannot have a presentation about employment law if we don't talk about COVID-19. So I just really, really briefly wanted to touch upon these 3 points in relation to COVID and how it impacts employers. So number one, of course, the very special COVID-19 period that was added into the Employment Standards Act, that is ending as of this month. And I do not believe the government is going to extend it, as opposed to all the other times. For employers watching this, if you've been along the ride over the past 2.5 years, the first extension, they did it basically the night before. It was to end. But really, I think with the way the government has approached COVID-19 over the past several months, I don't think it's going to be extended anymore. So the lesson there, or the note for employers, is if there are any employees who are still on a COVID leave of absence, they may still be working, they may not be working. Maybe their hours were adjusted, maybe their pay was adjusted. That period ends July 31st of this year. And so after that time, whatever changes that happen to an employee's employment, they are to be reverted back. If you have questions about that, I'm always happy to talk about that offline. To be really brief, the vaccination policies, currently a lot of them are not in force. Could they come back? Of course. There are new vaccines that I hear are going to be made in the future. other boosters, vaccines based on other variants. And so as time goes on, I think it's prudent for employers to update their vaccination policies and to put them in place or to put them on hold as appropriate for that workplace. So, but a lot of them currently are not enforced, but we are seeing some decisions from judges and arbitrators now coming out in relation to the vaccine policies that were in place before, specifically with regards to religious exemptions. And there have been 2 labor arbitrators in Ontario who have permitted employees to be accepted from a vaccine policy based on their religious beliefs, which is something that I was surprised to read those cases, those arbitration decisions. So that's in the unionized context. And so, the law isn't fully, the law is subject to change. The law is, it's growing. It's a living tree, as some constitutional lawyers would say. And so the religious exemption to vaccines, that is probably the newest area, and it's really a changing area. The court, Ontario courts have not dealt with it yet, only labor arbitrators. So that is, we're looking forward to seeing what judges have to say about that. So that's my brief, hopefully 2 or 3 minute update about COVID, because we can't not talk about COVID. But I wanted to touch briefly upon, like I said, the 2 pieces of legislation that probably now all employers know about. And if you don't, this is your time to take notes. The Working for Workers Act in 2021. So it came into effect January 1st, 2022. And these are the most important pieces of that legislation. The right to disconnect policy has got the most attention in the media and with employers, because if you're an employer with over 25 employees, you must have a written policy on the right to disconnect. But that doesn't mean you have to provide a freestanding right to disconnect to employees. The law is very clear. The law on the right to disconnect says an employer who has more than 25 employees, as of June 1st of this year, you have to have a written policy. It has to define the right to disconnect, and that policy has to be given to every employee. That's what the law says on the right to disconnect. The law does not say every employee must get a right to disconnect, right? If you contrast that with breaks, of course, the Employment Standards Act says every employee gets a break after having worked 5 hours. Can't work more than 5 hours without having a break. That is a right that's given to employees. But there is no right to disconnect. It is only a requirement that the employer have a policy called the right to disconnect, has a definition for the right to disconnect. So, it's something that, got a lot of attention in May and June of this year, and I'm still helping some employers to craft the right to disconnect, pardon the pun. So if you have questions about that, I'm always happy to discuss. Non-compete agreements got some attention there. Now, as of October of last year, any non-compete agreement that is coming into effect after October 2021, they are void. So an employee who signs an employment agreement at any time in 2022 or past that has a non-compete agreement, that non-compete agreement is void. It's very similar to the no pets provision for renters. And that is, if a lease says no pets allowed, that clause is automatically void, even if they signed it, even if everyone agreed to it. So, and even before that, non-compete agreements were rarely upheld by the court. And when I say by the court, I mean when the employer sues the former employee for breaking the non-compete, goes all the way to a hearing, and a judge says, I'm not really going to uphold that non-compete, especially if you have a non-solicit. Non-solicits are totally fine. But the non-compete agreements, as per the legislation, as of October 2021 and going forward, any non-compete agreement with an employee is invalid. There are 2 exceptions. If that employee has in their title the word chief executive officer, chief information officer, then a non-compete agreement can apply. And also in the context of a sale, if an employee is part of the sale, as in benefiting from the sale, and specifically doing the sale, I should say, and that seller stays on as an employee, there can be a valid non-competition agreement applied to that employee. So there's some very narrow exceptions, but generally for the average employee, even before this Working for Workers Act came out, there was not really an appetite to enforce non-compete agreements. For temporary help agencies, if there are any temporary help agencies watching today, there were some new changes put into place. They haven't all come into effect, so I won't go into great detail about them. But what I will say, if you're an employer and you use a temporary help agency, once all of the parts of the law are in effect, there will be some other requirements on any employer using a temporary help agency, specifically related to licensing, right? They're going to be licensed, not right away. The plans are in place, and it'll be up to the employer to ensure that they use a licensed temporary help agency. So for any employer using a temporary help agency, not right now, in the future, there will be some requirements on employers using temporary help agencies. I mentioned the end of the COVID-19 period, end of this month, so that's significant. Will there be increased litigation if employees don't get their exact same job back as they had in May 2020, March 2020? We will see. So if you're an employer and you have employees whose jobs have changed because of COVID, speak to an employment lawyer, and of course I'd be happy to chat. And there are also changes related to, this was interesting, in the Occupational Health and Safety Act. Washrooms for delivery drivers. If you have any type of delivery driver, not just Amazon or any type of delivery, it is an obligation of the employer to provide that delivery driver with a washroom. I think that's reasonable. I don't think it's controversial. I think probably most employers had done it anyways. But really, I think they were targeting the Uber Eats and DoorDash and things like that, where they kind of say, get in and get out. But now, of course, I think it's completely reasonable for those employees to have access to a washroom. So those were the changes in the Working for Workers Act 2021. And a few months after that, the government came out and said, okay, now we have a new law called the Working for Workers Act 2022. And this one has come into effect. There were some more changes, I would say, in terms of the amount of changes. And there was more of a impact on occupational health and safety than the first Working for Workers Act. But I would say the key takeaway from the Working for Workers Act 2022 is the electronic monitoring policy. Now, this is not in place just yet. So this is if an employer has more than 25 employees and they monitor their employees electronically, as of October of this year, they have to have a policy that clearly states what type of monitoring is done, how they do it, and why they do it. That's the kind of an overview of that. So if you're an employer and you have 5 employees and you electronically monitor, you do not have to have the policy. If you do not do any electronic monitoring, then you don't have to have the policy. But if there are if you do any electronic monitoring, I would say for an employer of any size, it really doesn't matter. I think it's a very reasonable policy, and really where that stems from is the fact that no employee has a complete right to privacy over what they do on their employer's equipment. There is actually there was just a case that just came out last month from a labor arbitrator, that talked about the right of privacy for teachers, and that was an interesting decision in a unionized environment, but for the average employer who monitors their employees electronically, I would say it's a reasonable policy, and I've been helping already employers to develop those policies and to make sure they're rolled out appropriately. And you know what? There are lots of employers who already disclose, yes, we use keystroke software, or we retain we have an AI system that reviews the internet history. We have a system that monitors how long an employee is active on our computer systems, right? Or you've heard of, the systems that monitor if the screen is being used, okay? Or even, if you have any AI or that reviews, employee chats, if you use a more detailed chat system. So those are all just some examples of electronic monitoring. And like I said, as of October of this year, employers will have to disclose that in a written policy. So I would say that was the, one of the most important changes to the law. It really, I don't recall hearing any stakeholders asking for that, but it is the law and it comes into effect in October. There was a brand new law that talked about digital platform workers. I won't talk too much about that, but if you're an employer and you hire employees through, or you engage workers or employees or contractors, through a digital platform, there is a brand new law that relates to giving certain rights to digital platform workers, but not every right that you would find under the Employment Standards Act, only some of them. So the government is saying there are, those types of workers out there, we want to make sure they get certain rights. And so I'm happy to speak about that in greater detail. I won't speak about that right now, but there were some big changes to digital platform workers. It did get some criticism. Some stakeholders were saying that it's not really, it doesn't really provide them protection. It actually provides the employer of those employees more protection. But that, is yet to be seen. We haven't seen any of the new law being tested in court yet. It will take some time for that to take place. There are also changes with regards to IT technology consultants. So if you're an employer and you hire IT workers, you'll know, first of all, there's a very specific definition of who is an IT professional, an IT worker. And there were some new changes related to how those employees are treated. And so I won't go into the fine details. It doesn't really relate to every single employer, but there were some important changes, and it's important for employers who hire those IT workers to understand how the law has changed in relation to engaging those types of workers. So it's very important. And again, I didn't really hear personally, that was required from any stakeholders, but you compare that to Bill 168 a few years ago, several years ago now, those employers who, there was a big government white paper that was made several years, and the Liberal government at the time came out with all those sweeping changes to the Employment Standards Act. That was anticipated, it was expected, stakeholders were really consulted a lot. Here, there's probably some consultation, but I was surprised to see that in the amendments to the law. And the last set of changes with regards to in this Working for Workers Act 2022 related to health and safety. They really were, this was some very large changes, and they were done quite quietly. I didn't really see it picked up by the media. So number one, I put fines on there twice because they increased so much. So the health and safety fines, they increased for directors and officers of corporations. So not the corporation itself, okay? The maximum fine currently, and before the law and after the law for corporations, the maximum fine was 1.5 million, but it was not the same for directors and officers. Now it is the same. The maximum fine under the Occupational Health and Safety Act for directors, officers, and corporations is now $1.5 million. That's significant. Does every fine through the Ministry of Labor, through their prosecutions, does every fine hit $1.5 million? No, but this is the indication from the government to the court to say, this is the maximum fine. So now judges will take notice of that and say, well, if that's the maximum fine, this is, seriousness of this incident that was found to have occurred, and this is the fine that's going to be given. It was previously 500,000, went up to 1.5 million. So directors and officers of every corporation in Ontario should take note of that specifically and ensure A, they have proper insurance, B, that the corporation itself is taking every step they can to protect workers in the workplace. That's really the pinnacle of the Occupational Health and Safety Act, is that employers must take every reasonable precaution in the circumstances to protect workers in the workplace. And that's must. It's an obligation. It's a legal obligation on employers. There are also obligations of supervisors. There are also legal obligations of employees, but the bulk of the obligation falls on the shoulders of the employer. Excuse me. So now officers and directors are equally, they could be equally fined up to $1.5 million. So that was significant. There is a requirement to have naloxone kits for not every employer. It's where an employer has information, or that employer ought to have a naloxone kit because of information they know about their employees, information about the industry that they work in, industry of geographically where they're located, for example. If it's reasonable for that employer to have a naloxone kit, they must have the naloxone kit. They are available through pharmacies and through the government, so it's not. I don't think it's a prohibitive cost. But the question or the issue is, if an employee really needs one, and if the employer should have known that employee needed a naloxone kit, is it there? And now the government is saying, yes, you must have that naloxone kit there. And the last point here, this one I really want to draw attention to as well. The change was the Ministry of Labor now has 2 years to investigate a potential infraction of the Occupational Health and Safety Act in a workplace. This was a change from 1 year. It used to be 1 year, now it's 2 years. This is to investigate and to bring a prosecution. If we look at the grand scheme of things, to bring a prosecution against the company, against the director, against the officer, against a supervisor, or against an employee, right? That stems from the investigation, which now they can take 2 years from the date of the investigation. And the ministry has 1 year after the last part of the investigation to bring a prosecution. And I can tell you, during the COVID period, if you're a close follower of the occupational health and safety fines and prosecutions, just now we're starting to see, the decisions come out of the Provincial Offences Court, which is where those prosecutions are heard and decided. And there are now, I'm starting to see decisions and fines related to COVID. And COVID, safety, health and safety infractions, an employer didn't do enough to protect workers in the workplace from COVID. So it is now the ministry, has a lot more time to commence and do their investigation. So that's significant. So if there was an incident that happened, a year and a half ago, and maybe that employer thinks, okay, well, it's in the past, now I don't have to worry about it. Well, now the ministry has more time to investigate that. So that's also significant, because it is a higher burden for an employer to prove that they took every reasonable precaution, as I said, took every reasonable precaution to protect workers in a workplace. And that's really, like I said, the pinnacle of the Occupational Health and Safety Act. So I'm just seeing some questions, and I thank you, Matthew, for answering the question. The naloxone kit, and I should have explained, the naloxone kit, it helps to save a person from an opioid overdose, as Susanna, and thank you, Susanna, and Anna as well, to help someone who's experiencing a drug overdose, specifically from opioids. So they're available at pharmacies and on the Ontario government website. I'm sure you can find more details about that. So those were the changes related to the legislation. But I also want to review 6 decisions, which might be a lot. I do want to save time for questions. So if you do have questions, make sure you put them in and I'll get to them by the end. 6 cases that were released in the past 6 months. And actually several of them from the Ontario Court of Appeal, which means it is binding on every superior court in the province. And every Superior Court judge is going to know about those cases. Lawyers are going to make sure that the Superior Court is aware of what the Court of Appeal says. Of course, the Court of Appeal is a higher court, and it's binding on the Superior Court of Ontario. But overall, my general advice to employers is, in light of these decisions and in light of the legislation changes, of course, it is prudent to review and update policies, and also, the HR strategies behind the company's, decisions and future steps. And it's also important to review employment contracts, and not just to review them, but review the existing contracts that an employer has, to review the templates that are used, maybe by the junior HR person. Let's check and make sure that the template that they're using is up to date as of 2022, not 2021, not 2020. There were big changes that happened in 2020, so hopefully templates are updated since then. But the law continues to evolve. So there's six areas of the law that I wanted to, or 6 cases within the law I wanted to talk about. So the first one has to do with harassment and termination, and I just found this kind of photo online. Harassment is it's an expansive definition of harassment. Harassment is conduct that is known or ought to be known to be unwelcome to a worker, or vexatious or unwelcome to a worker in a workplace. It includes sexual harassment, but there are lots of examples of harassment that are not sexual harassment, and it's got lots of attention. Of course, HR practitioners know there was a big push several years ago with harassment policies, which of course must be reviewed once a year. There should be proof of reviewing and updating the harassment policy once a year. It's important to, yes, document the day that it was reviewed. It is a legal requirement for every employer in Ontario to have the policy and to review it. And if there's ever a prosecution, what I ask my clients is, show me, this is 6 or 8 years ago now. So I want to see 6 or 7 or 8 different dates of when the policy was reviewed once a year, right? And that's exactly what the Ministry of Labour would be looking for as well, if there's an issue with harassment in the workplace. But the case that came out from the Ontario Court of Appeal, so it was a decision from a lower court. The takeaway was one single incident of misconduct. It may be just cause, but in this particular case, it did not constitute willful misconduct under the Employment Standards Act. What was that conduct? Well, a male employee slapped a female coworker on her buttocks. Apparently, it was done in the heat of the moment. It was in reaction to a slight that apparently the female employee made. And the male employee slapped the female employee on the buttocks. So I went to the Superior Court. There was a decision made, but that doesn't matter, whatever that court said, because the Court of Appeal said, you know what? That single incident may have been enough for just cause. And that employee was terminated for just cause under the common law. But was it enough to prove willful misconduct? And the Ontario Court of Appeal, based on the facts of this case, said no, it wasn't. Why is that so important? Well, keen HR practitioners and employment lawyers and employers will know that's a specific term under the Employment Standards Act. And if you want to avoid paying an employee the maximum of 8 weeks for notice of termination, or severance pay, which could be a maximum of 26 weeks of pay, one way that can be done is if the employee is guilty of willful misconduct. So in this case, the outcome was the judges confirmed, yes, the employee was terminated for just cause, and that was appropriate because it was a serious, one serious incident. But because the employee was not found guilty of willful misconduct, he still received all of his ESA minimum termination entitlements. So an employee who is I'll confirm that again because it sounds backwards, but this is the operation of the law. You can terminate an employee for just cause, but that doesn't mean you pay them zero amount of notice of termination after you terminate them for just cause. If you can't prove that they were guilty of willful misconduct or disobedience or willful neglect of duty that is not trivial and not condoned by the employer, the Court of Appeal says, based on this case, you have to pay them the minimum amounts of termination pay. So this employee, I don't actually have the amount of pay that he received, but it was calculated somehow by the lawyers in the court. This one, aside from my personal thoughts, it really is a message to employers. They have to proceed with any termination, especially a just cause termination, with, they have to do it very carefully, okay? And it is prudent for whenever there is, of course, you're going to do an investigation for a just cause termination, of course. That's what the court expects. There are other cases that say that. There are other cases where an employee, there wasn't a sufficient investigation into the just cause allegations, and the just cause was overturned, and the employee got full notice of termination, the minimums and the maximums. But this one, just because you think you have just cause, does not necessarily mean you can let the employee or terminate the employee's employment and pay them nothing. A big wake-up call, this case is. And again, released in 2022, just a few months ago. And I do understand, and I know that the case was not appealed to the Supreme Court. You have 30 days to appeal a case from Superior Court or the Court of Appeal to the Supreme Court. And the employer in this case did not choose to appeal. So this is good law. And I want to draw attention to specifically what the Court of Appeal said. Okay, and again, the conduct we're talking about here, and I'm spending a little more time on this because, again, I think this is a very important case for employers when they're talking about discipline, when you're talking about progressive discipline, and of course, termination. So the judge found that this employee did not pre-plan the conduct. Okay, they found that it was done in the heat of the moment. That was the evidence that was given in the lower court. That evidence it's not new evidence in the Court of Appeal. They just used the evidence that was brought previously. So conduct for the Court of Appeal, conduct that is careless or thoughtless. This is a direct quote. Careless, thoughtless, heedless, inadvertent conduct, no matter how serious it is, does not meet the standard for willful misconduct. So an employee who makes a careless mistake, no, that is not willful misconduct. The importance here, and people who have heard me do presentations before, or I've given them advice, they will know that I say, listen, this is not regular misconduct. The court and the legislation, and now the court says, no, it's not just misconduct. It's willful misconduct. You have to go above and beyond. And that means, and according to the Court of Appeal, there has to be a subjective intent of that person who committed the misconduct. They have to know what I'm doing is wrong. All right. And in the lower court, the judge didn't make a finding that this slapping of the buttocks was pre-planned. I think it is really, like I said, this is a big wake-up call for employers. If you're going to prove that certain conduct is not tolerated in your workplace, you should make it very clear. You can even use whatever examples you feel are necessary. And if you want to use one employee slapping the buttocks of another employee, feel free. You can say, this conduct is not appropriate. It is not acceptable, and we will consider it harassment, and we will, investigate it. And no employee, again, it's not. I'm not going to call it common sense because there's some saying about common sense. You can clearly state no employee is permitted to touch another employee ever, except if it's an emergency situation, you have to do CPR, or you have, the employee's consent to do so. But even still, there's no need for that to take place, or unless it's part of that employee's job duties, fine. But for this employee, it was just they're a more technical employer, but there was no need. It was kind of done in jest. That was the evidence brought forward. So this one, like I said, there's got to be more training that's done. Policies need to be reviewed because of this, and the type of conduct that is acceptable in the workplace needs to be clearly stated to all employees. Because this employer, even though they did terminate for cause, they had enough for cause, they still have to pay the employee. And of course, they pay their own lawyer and they pay the other side's legal fees too, because they lost at the Court of Appeal. So that's my discussion on that case, a very important case. And I'm always happy to talk more about, for cause, willful misconduct, willful disobedience, willful neglect of duty. Let's talk about briefly a case about legal advice and whether an employee receives legal advice while they're negotiating their contract. This is in the pre-employment stage. So there was a case, again, from the Court of Appeal, different judges. A Court of Appeal, they have 3 judges, not just one. At the Superior Court, 1 judge will decide. Court of Appeal, typically, for most decisions, there will be a panel of 3 judges who review the case and decide. This case was interesting. It confirmed what a lot of employment lawyers knew. If you have a termination clause and it's a deficient termination clause for whatever reason it's deficient, let's say it doesn't have the magic words that I've talked about in other presentations. If it's deficient, it doesn't matter what the employee did to get to that point. If it's deficient, it's deficient. If the court's going to ignore it, it doesn't matter if the employee got legal advice to negotiate it. And this is what the Court of Appeal decided in this case. The lower court actually sided with the employer on this case at the lower level, okay? But that was appealed by the employee. The employee won at the Court of Appeal. So however sophisticated an employee is when they negotiate their contract, if the termination clause is bad, the termination clause is bad. And the court also made more of a point to say, even if you try and add in a clause that would save that clause, the termination clause, they don't care. Court doesn't care. Termination clause has to be crystal clear at the time when you use it. Doesn't matter when you wrote it. If you wrote it 15 years ago, but it's not clear now, it's what matters now. And the employee can talk to 10 lawyers and negotiate with a lawyer, for example. Doesn't matter. So that one, it made some waves in the employment law bar. The next case, termination pay. So, employers and HR practitioners here, they understand, an employee, if they're terminated without cause, there's notice of termination, there's termination pay, there's ESA severance pay, there's, and of course, common law reasonable notice. That's the amount of termination pay that a judge feels an employee should receive based on not just the minimum factors, but, their age, their length of employment, type of employment. This was a case that came out in March of this year, again, from the Court of Appeal. So this went from the trial level, was appealed to the Court of Appeal. This employee received greater than the cap of 24 months that the same Court of Appeal set. The Court of Appeal said, you know what, we looked at this particular situation, and yes, we agree that 26 months of termination pay is appropriate for this employee. So who is this employee? This is important. And like I said, when we're talking about common law, notice of termination, not the minimum. ESA minimums are the minimums, great. But there's also the maximums in the common law. We look at many different factors, not just 3 or 4. There's a list. There's 15 or 20 different factors. The most cited factors by judges are the age of the employee at termination, the type of employment they had at the time of termination, the length of employment, and generally how easy or difficult it will be for that employee to find new employment. Well, this employee left high school to work for this employer. Okay, when she was 18 years old, she left high school, and that was 40 years prior. She had one employer. That's an important factor. Okay, at the time of termination, of course, she was 18 when she started, worked for 40 years. She's 58 years old. The Court of Appeal found that a termination of that employee who had worked for 40 years, 58 years old, she was in a highly specialized role. They called it equivalent to a forced retirement. That's what the Court of Appeal said. So the court said, and she had started, let's just confirm, I didn't do the math, I'm going to go by the Court of Appeal's math, 1979, she started. Someone who applied for a job in 1979 the court will take note that it is a whole different ball game, a whole different paradigm. If you're applying for jobs in 2020 or 2021 or 2022, probably 2020 or 2021 she started. She was terminated. So the court said, you know what? We know that the Court of Appeal said, we said that the 24 months is the maximum an employee will get, except for extenuating circumstances. Here are the extenuating circumstances. Working for 40 years, working for one employer, highly specialized job, probably difficult. And there was evidence that it was difficult for her to find similar job. The job landscape has changed. She received greater than 24 months. She didn't receive 40 months. It's not 1 month per year of service for every year that you work. That's what some lawyers say. That's not necessarily true. It's not true all the time. This employee got 26 months, which is the watermark, the high bar for employees. Not every employee is going to get that. But that was an important case that came out in March from the Court of Appeal. And there was another case, and I wanted to just draw some attention to that. This was Gaskell and Newmont, Goldcorp. This was released, this was in the trial level decision. And an employee received $50,000 of tax-free money, general damages, for the untruthful, misleading, and unduly sensitive conduct of the employer. Specifically, what happened in this case, the employer was selling their mine, and they had made certain representations to the employee that, yes, your employment is going to continue with the new owner. Typically, that's what happens. I'd say the vast majority of cases, when there's a sale, all the employees continue. And maybe some don't. That's an exception. But almost, all employees continue. That's what they told this employee. But something changed. Something changed throughout the closing, and 2 months later, the employer, whether it was the buyer or the seller, it doesn't matter, but there was evidence that, we're not going to keep him anymore. But they didn't tell him that. They failed to tell this employee when they knew, at the time they knew they weren't going to keep him on. They didn't tell him that. But they knew 1 week before closing, and they still didn't tell him, closing of the sale. And so the court said, it was untruthful, it was misleading, it was insensitive. And when you have words like that used by a judge, an employer can expect a decision of general damages, an award of general damages against the employer. And there was also facts in the case that the employee had usually received a large bonus, and the employee didn't receive that, right, as a result of the termination. And it was a very quick, like I said, a quick termination, even though they promised him his employment would continue. So any promises that are made to employers from employers to employees, my apologies, we have to be very careful. And if something changes, and time is of the essence, it's important to express those changes to the employee. There was a case related to COVID leave and the COVID leave of absence, like I mentioned, that's ending very soon. And I have a picture of course, some places were closed. A lot of them are open now. The Court of Appeal in April heard arguments about this case that's called Taylor and Hanley Hospitality. And in the arguments made to the Court of Appeal of Ontario, the lawyers were asking the Court of Appeal to decide, is this IDEL, infectious disease emergency leave or COVID leave, is it a termination or is it not a termination? And keen watchers of employment law will know in the Employment Standards Act, there's a special little provision that says if you place an employee on this special infectious disease emergency leave, it is not a termination. It is not a layoff. That's what the Employment Standards Act says. But the court hadn't weighed in on it. So the lawyers went to court based on this employee who was, she claimed she was terminated because she was put on a COVID leave. The lawyers wanted to make that, wanted the court to make a decision. So we were waiting for the decision. We got the decision. The court didn't decide. The court did not say whether COVID leave is a termination or not. So we're still waiting. So if we want to get technical, technically what the court said was, okay, the way that they brought that case forward to Superior Court, to the Court of Appeal, it was not the right way for the Court of Appeal to make a decision on whether COVID leave is a termination or not. So they declined to make a decision on whether or not COVID leave is a termination. They said you have to go back to a trial. I actually attended virtually the appeal. I thought the lawyers did a fine job on both sides arguing their case. It really is this is probably right at the cusp of where employment lawyers are pushing the interpretation of the law, and both sides made really, really good arguments. And after I viewed the arguments, I said the court's going to have a tough decision to make. And the court said, nope, we're not even going to make a decision. They heard the arguments, but they said, we're not going to make a decision on that because the way you came here, it was like a procedural, they denied the appeal based on procedural reasons, not on the substantive, the actual reasons of the case. So suffice to say, we are still waiting for the court. We're waiting for the right case to come through. Perhaps this one will be taken to a full trial. I'm not sure. I haven't spoken to the lawyers yet on that matter. It wasn't one of my cases, but we are still waiting. And again, COVID leave expires the end of this month. If there are any employees who are currently on, if you've changed their job, their hours, their pay, if they're on a complete unpaid leave of absence, if it's a partial leave of absence, 1 day a week, they're working 4 days, you've changed their pay, whatever it is, speak to your HR people, speak to an employment lawyer, and consider, really understand what your obligations are in relation to that COVID leave of absence. There was a case regarding independent contractors. So we're almost near the end, and I see there's some questions here, and I will get to the questions at the end of the presentation. But I want to just talk briefly about this case about independent contractors. I know there are a lot of employers who hire contractors. Are they independent? Are they dependent? Are they an employee or not? There was a case that came out this year through the trial level at the Superior Court. And in this case, actually, for the plaintiff and for the principal for the Westport telephone, there were the court found that he was an independent contractor. And typically, when those cases get to hearings, courts usually say, well, you know what, I'm pretty sure they're an employee, because it's a case, it's a analysis that's been done by many judges at all different levels: Superior Court, Ontario Court of Appeal, Supreme Court. The Supreme Court has addressed it in its history. The Federal Court, the Federal Court of Appeal, the Tax Court, they have all addressed this issue of who is an independent contractor, who is not. So I want to draw specific attention to some important factors of why this court found that the worker was an independent contractor. Number one, there was a complex corporate structure that was made with the help of professional tax advisors. He did work full time for the principal, but he also was a shareholder. He was an officer. He was a director. He owned shares in the company. And there was evidence that only 50% of his income for certain years came from this principal, and his income came elsewhere. So he wasn't fully dependent on the principal. But there's also, there's a lot of arguments made about well, how dependent does one worker have to be independent or dependent? And there was also, there were other factors that came into it, but the corporate structure was really important for the judge in this case. And they found that, the worker may have been integral, but to the principal, but this principal did not give the worker, the majority of the income. So for those reasons, and some other reasons, the court found, no, you truly are an independent contractor. So I would say that's a win, for the employer in that case. But I'd say generally, whenever there's a decision about who's a contractor, who is an employer, it is always a fact-specific analysis. It is a very detailed analysis, in fact. If any employers here have been audited by the CRA, and CRA has said, well, we have a 20 or 30 or 40 questionnaire that you have to fill out related to very specific questions about how do you deal with this worker? How do you pay them? Is there control? Who pays for the tools? What's their opportunity for profit? What's the risk of loss? Where's the contract? Do you have a subjective intent? Is there an objective intent to be independent? And of course, many other questions. So I wanted to draw employers' attention to that, because if you have independent contractors, it's always a fine idea to have it reviewed by an HR professional, an employment lawyer, just to make sure. Oh, and that was the last case. So we're good for time. I am going to look at the questions that we've received, and if anyone else has any other questions related to what I've talked about, or another topic that you wanted to get my ear for, I'm happy to answer those questions. So someone has asked a question here. If the Employment Standards Act can't find the employer's or company's financials, and that employer owes an employee money, is there anything employment standards can do? Well, yes, of course. There's really two ways that the law says that an employer might have to pay. One, it's through an employment standards complaint. Okay. Number one. Number two, it's through court. So it's up to that person to decide how they want to proceed against their employer, right? The Employment Standards Act makes it very clear in terms of payment of wages, in terms of vacation pay and breaks, and leave of absence and things like that. And there are also requirements about record keeping that are directly in the Employment Standards Act, and it's up to every employer to keep very good records of vacation pay, of wage statements, and they have to keep it for many, many years, not just 1 year or 2 years, 7 years. They have to keep those records for. So is there anything employment standards can do? Of course. The Employment Standards Act has certain ways, and the court has certain ways. And if you can't find the money, well, you need a lawyer to help find that money. And I think, Matthew, I see you, you have your hand up. Did you want to ask a question directly?
Yeah, hi everyone. I went through something similar with this with an employer in the past. That's why I asked the question. And it went through the Employment Standards Act, Ministry of Finance. They haven't been able to do anything. And they literally told me that they probably won't in the future. So am I do I have to pay for my own lawyer? How does that work?
Yeah, it's up to you as an employee to determine how you want to proceed. You can proceed with an ESA complaint, and you can proceed with a lawyer. So I would say it's best that you get a legal opinion from a lawyer. You will probably very likely have to pay that pay for that service, but you'd have to I would say you need to speak with a lawyer about that. That's about all I can say here in a.
That's fine. Thank you.
In a webinar, of course. Someone else has asked a question, and it was a direct message, but so I won't say the person's name, but I will ask the question kind of out loud. It says, "What about employee privacy related to needing naloxone?" Good question. That's a great question. So when we're dealing with sensitive information like that, of course, privacy is key. if an employer is aware that an employee might need an naloxone kit, they don't have to confirm it with the employee. That's not what the law says. The law says if the employer knows or ought to know that a naloxone kit might be needed by any worker, okay? Worker as an employee, contractor, part-time, casual, even it doesn't really extend to visitors, but occupational health and safety has to deal with workers. So any worker, although a delivery person is not your worker, but they do provide services to the business. You don't have to ask the employee. You have to have it available. You should have a policy. If you want to do training on it, you can do training on it and have it available. Okay. So the question will really be, was the employer aware? And should the employer have been aware that they needed to have an naloxone kit? If an employer is aware of more details, specifically, that the employee, maybe they're coming in late all the time, they're acting erratically, their performance is down, we don't always jump to termination. There is a duty for employers to inquire if their employees need accommodation. So if an employee has, if they're giving you a lot of red flags, it is prudent, and really the human rights law says regarding accommodation, you have a private meeting with that employee and you ask them, you inquire as to if they need any accommodation. So it could be done sensitively, of course, but to have a policy on naloxone and to have a naloxone kit, you don't have to ask permission for anyone. You can have it. You can have the policy. We have another question from Tina. It's a really good question, a loaded question, but I'm going to do my best. What's the best way to determine whether an employee is an independent contractor? The short answer is to speak to an employment lawyer, Tina. Now that's a little glib. I apologize. So there's a 4 or 5 part test, depending on which lawyer you talk to, depending on which case you want to read. But the court and the CRA and all of the levels of court will really look at 4 important factors, sometimes 5. 1, control. How much control does the principal have over the worker? 2, the tools. The tools of the trade. How does the worker use the tools, and who pays for them? That's important. Is there an opportunity for the worker to make a profit? And is there a risk of loss for the worker? Those are 2 very important factors, and they link with the other 2. And the last part of the test generally is, is there a subjective intention of the parties? Really, is there a contract? Okay. But like I mentioned from that case, an important factor was that the worker and the principal had these complex corporate structures. And I think that really speaks to how much control there was, and tools of the trade, and opportunity for profit, risk of loss, right? Which also links into how much income did that worker actually make from the principal. There was evidence that it was around 50%. So that worker wasn't completely dependent. They were quite independent. But there's also cases that set how dependent, what is a percentage that a contractor has to rely on the principal to be independent. It is argued by lawyers in many different cases. So it is a loaded question. I do see we have about 2 more minutes, and Thomas, you have your hand up. Nazi, I might not be able to get to your question, but if you email me afterwards, and here's my emails on the screen, I'm always happy to chat. So Thomas, you have about 1 minute to ask your question.
So it's a quick two-parter. Thank you for your time. Regarding the recruiting, third-party recruiting, focused primarily on this type of service. The way that I kind of read the law was that it also applied to third-party direct hire service account acquisition as well. Am I misreading that? This is really the first question. And then the second question is there a burden on the organization outsources this type of service to ensure that these organizations that they're using for needs are licensed?
So I'll answer this. So I had a hard time hearing you, but I think I heard everything. So he has two questions related to using recruiters or using temporary help agencies, employee agencies in bringing in workers to the company. So the second question was, does the employer have obligations when engaging like a recruiter or the recruitment agency? The answer is yes, they do. And from off the top of my head, because I don't recall every single detail of that part of the law, one of them I know for sure is that the employer has to, they have to receive proof that the recruiter is licensed. Okay, but it's not in place yet. So the law exists, but it's not in force. So if you ask a recruiter, if you ask a temporary staffing agency to see their license, they're going to say, we don't have it, we don't need it, because that's the case right now. So the government, they implement things sometimes very quickly and sometimes they take a little more time. That one, the government's taking a little more time. So really, to answer your first question, well, who is a staffing agency, a recruiter, who does it apply to, third party? I would say right now we don't know for sure because it hasn't been fully rolled out just yet. So who's supposed to get the license? Honestly, off the top of my head right now, I couldn't tell you, and we're waiting for that greater and more information, more detailed information to come out. So maybe in 6 months from now, Thomas, I'll be able to answer your question. So on that note, I will thank everyone. Nazia, if you email me with your question there, I can discuss with you about director and officer liability with relation to health and safety. But thank you everyone for coming today. I hope it was informative.
Thank you very much, Jonathan, and thank you to Kaiser Mason Ball for hosting a series of webinars with us. I think this is the last one for the summer, but we're back in September with quite a few more webinars, just like this one with great speakers from Kaiser Mason Ball. So keep a look at our website, mbot.com/events. We update it weekly with new events, one to come for our year-end patio party coming up this week. So take a look to register. The event will happen in mid-August. We look forward to seeing all of you there. Thank you very much, Jonathan. It's always a pleasure to have you on. So thank you for joining us today. Have a fantastic day, everyone. We look forward to seeing you soon. Take care.